Hello everybody, I'm S. Kirti and today we are going to discuss about rights and liabilities of lessor and lessee. So the concept of lease, it's given under section 105 to 117 of Transfer of Property Act 1882. So lease is one of the modes of transferring of property for a particular period of time. So this is a mode of transfer. Unlike sale and mortgage, here there is a particular period of time which is insisted upon, and lease is a transfer of an interest in the property for a stipulated period of time, whereby the main point here is only the transfer of possession takes place and not the transfer of ownership. So here the transferor of the property is called as the lessor, and transferee of a property, that is the one who is enjoying the property for a period, is called as a lessee. So definition of lease is given under section 105 of the Act. Here it states that the definition of a lease is it is a transfer of immovable property for a particular period of time for a consideration of which the transferee has accepted the terms surrounding the agreement. So this is the definition of lease, whereby the important essentials are it has to be an immovable property, there has to be a particular time period, and there has to be consideration, and the transferee should have accepted the terms and conditions of the agreement. So what are the essentials of lease? The first essential is parties must be competent. That is, they must both be competent to enter into a contract, majority, say sanity, and they should not be disqualified by law. And the lessor should be entitled to a property and should have absolute right over the property. The second is right to possession. Ownership rights are not transferred in a lease, but only the possession of a property is transferred. So the next essential is rent. There has to be a consideration, as I said before in the definition part, and this consideration can be taken in the form of a rent or premium. The next is acceptance, where the lessee, who is actually to get the interest of the property after lease, he has to accept the lease agreement, its terms and conditions, along with the time period that is imposed upon the transfer. And the last is the time period. Time period, a lease always takes place for a particular time period which has to be specified in the lease agreement, and this time period can be relaxed at the option of the lessor. So there is a point here, what if the time period isn't mentioned? So if the time period is not mentioned, section 106 of the Act will come into take place, where it tells that if there is no time period, then the lessor or lessee have to give a notice of quitting. So after this notice of quit is given, there is a period of time, that is 1 year in case of agricultural and manufacturing purpose, and 1 month in case of any other purpose. So after this period is over, then the lessee has to go out of the property, and that is they have to return the possession of the property to the owner. So what is the determination of lease? Determination of lease is given under section 111 of the Act, whereby it tells about a various kind where the determination of lease is done. That is how a lease is being determined. One is the lapse of time. When the prescribed time of lease expires, then the lease is said to be terminated. And the next is a specified event. Specified event in the sense when there is a condition on the time of lease depending upon the happening of an event, and this happening of an event has taken place, or if it is not taken place, depending on the condition, then the lease will come into a stop. The next is interest, where the lessor's interest to lease the property may cease, hence resulting in the termination of the lease. And if both lessor and lessee becomes the same person, that is the lessee gets hold of the property from the lessor and he is both the lessor and lessee, then there is no need for a lease to be taking place. And then express surrender. This concept happens when the lessee ceases to have an interest in the property and he comes to a mutual agreement between the lessor in order to go back from the lease agreement. And implied surrender means if the lessee enters into another agreement with another person regarding another total complete lease, then this will be determined as an implied surrender of the existing lease. And the next is expiry of notice to quit. When the notice to quit by the lessor to the lessee expires, then the lease will also expire. And the last is forfeiture. Forfeiture has three ways. One is breach of an express condition, or if the lessor or lessee renounces his character and transfers his title of the property to another person, and if the bank declares that the lessee is insolvent by the banks, then he will not be able to pay any lease amount to the lessor, and then the agreement to lease will go away. Now, what are the rights of a lessor? Rights of a lessor, there are four kinds. One is right to recover the rent. That is, a lessor has a right to recover the rent from the lease which was mentioned in the lease agreement. And the next is lessor has a right to take back the possession of his property from the lessee if the lessee commits any breach of condition. And the next is lessor has a right to recover the amount of damages from the lessee if there is any damage done to the property. So if any damage is done to the property, then lessor has the right to recover the amount from the damages. And the last right of a lessor is the lessor has a right to take back the possession of the property from the lessee on termination of the lease term prescribed in the agreement. Now, what are the liabilities of a lessor? The liabilities of lessor are the lessor has to disclose any material defect relating to the property which the lessee does not know, and he cannot find about it during ordinary supervision of the property. And the second liability is the lessor is bound by the request of the lessee to give him the right of possession over his property. After the lease agreement is signed, the lessor should not hold the possession of the property, but in turn he has to give the possession to the lessee. And lessor can enter into a contract with the lessee if he agrees to abide by all terms and conditions that is prescribed in the agreement, and he can enjoy the property for the rest of the time period without any interference with an obligation to pay the rent later on. So this concept is called as covenant for quiet enjoyment. Quiet enjoyment means the lessor will not interfere with the lessee for the complete whole time period of that is mentioned in the lease agreement, and they will agree upon a condition that the lease amount will be paid by the end of the time period, and the lessor should not disturb the lessee between the time period. So now the next topic is rights of a lessee. The first right is right to accretions. Accretions, they can be defined as the additions that is made to the property either by human being or by operation of natural forces. So if during the continuance of lease, if any accretion has been made to the property, it is then presumed to be the part of the property. So accretion means that is made either by human intervention or any natural forces. Now, right to avoid lease on destruction of a property. So, where the property has been rendered substantially and permanently unfit for use due to any natural cause such as fire, flood, etc., like fire, flood, or violence, or mob, or any uncontrollable reasons. Here also it can be either human being force or natural force. Then the lessee has a right to get the lease terminated before the expiry of the term. And the next is right to deduct cost of repairs. If the lessor has no obligation to repair the property, because under an express agreement, the lessor may take the obligation of making necessary repairs in the tenanted property. The next is right to deduct outgoings. It is the duty of the lessor to pay for the outgoings. That is, where a lessee makes a payment of the public charge in respect of a tenanted property, he has the right to deduct the amount from the rents only and not from the any other lease amount. And right to remove fixtures. After termination of a lease, the lessee has the right to remove any fixtures that is made by him during the continuance of a lease. In case of a house, the tenants may come and fix about their fans or ACs or heater, and this lessee tenant has the whole right to remove his fixtures at the end of the lease term. The next is right to remove crops. After the termination of the lease, the lessee is entitled to remove the crops sown by him during the substances of the lease. This is in case of any agricultural purposes. And the last is right to assign his interest. A lessee has right to assign or transfer his right of enjoyment in the property. Right of enjoyment of an immovable property is a property that is owned by a lessee. So he can transfer it to any other person provided there is no prohibition. There should be no prohibition that is given by the lessor. Only then the lessee can transfer his property to another person. So the next topic is about the liabilities of the lessee. First liability is the duty to disclose any fact, as this is as same as the lessor, but the difference is just as the lessor has a duty to disclose a latent material defect to the lessee too is actually bound to disclose the lessor any fact that is known to him which increases the value of the property. And the duty to pay rent. Lessee is bound to pay the rent or premium as stipulated in the lease deed, but the tenant's liability to pay rent begins from the date on which he has possessed the property and not from the date of the deed or something, and not from the date from which the landlord signs the deed. So duty to maintain the property, the lessee is bound to keep and maintain the property in the same condition as it was as when he received the possession of the property, and he has to take reasonable care in keeping the property in good condition. So the next is duty to give notice of encroachment. If the lessee comes to know that an encroachment has been made on the property in his possession, then it is his duty to inform the lessor so that he may take any proper action, and it is the duty of the lessor to take any proper action over the encroacher and not the lessee. Now the duty to use property reasonably. The lessee has a duty to use and enjoy his tenanted property as a person of ordinary prudence would use his property, and he cannot use it unreasonably for for example, for any chemical purposes or nuclear reactors, which any normal person would not do it. And if he is going to do anything for any special reason, he is going to use the property, then he has a duty to inform the same to the lessor also. And duty to not to erect permanent structure. The lessee cannot erect any permanent structure on the leased property without the consent of the lessor. So if a lessee makes any permanent construction without the lessor's consent, then he is entitled to remove them without causing any damage to the tenanted property. And if the permanent structures on the leased property are not removed by the lessee, then on the expiry of lease, they will belong to the landlord, and the duty of that is the right of removing any fixtures made by the lessee will not be available to the lessee in case of any permanent structure that is made without the permission of the lessor. So the last duty is duty to restore possession. Upon the expiry of the term or determination of lease before its expiry, the lessee must retransfer the possession to the lessor. It is the duty of a lessee to vacate the possession and restore it to the lessor after the expiry of a term. So this is about the liabilities of the lessee. Now there are certain case laws regarding this where the court has held some important points. For example, in Ranak Ram versus Peshori Singh, the Supreme Court held that after the retirement of that particular partner, the lease will continue to exist and there is no subletting by a partner in favor of the firm, and this firm will be continue to be the lessee. So the next case law is Girdhari Singh versus Meghlal Pandey. The court held that the essential characteristic of a lease is that the property is occupied and the corpus of which does not, by reason of the user, will disappear. So there has to be a person in actual existence who occupies the property, and in the absence of that, then there is no such lease is taking place. And the next is Chapsi Bhai versus Purushottam. Here the Supreme Court has mentioned that a lease is permanent lease because the rights of a lessee or tenant are heritable, and such leases are not intended to be only for the lifetime of the lessee. So these are the three important points regarding lease that is mentioned in the various case laws in Supreme Court cases. So this is all about the rights and duties of lease, lessor and lessee. Thank you so much.